Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I've got to say it, but I've said it now. And we're going to move on because nothing is going to prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. It's crucial that you understand the role of your doctor in your short and long-term disability claim before you stop working and apply for benefits and even appeal a case. I'm going to be talking about four things today. Number one, what do your medical records say, and what isn't in your medical records can make or break your claim from the very beginning. Two, what an attending physician statement form is and how it's used in your disability insurance claim. Three, how the carriers evaluate your claim using disability duration guidelines. And fourth, I'm going to tell you a David versus Goliath story and the story of how one court took on Unum and took them to task for how they handled a fibromyalgia case. Before we get started, let's take a break for a moment. Welcome back to Winning Isn't Easy. I'm next going to talk about what an attending physician statement form is and how it's used in your disability insurance claim. Most disability insurance companies are going to ask your doctor to fill out a form called an attending physician statement form, an APS form. But what the carriers are also looking for is the office treatment notes to document the treatment and your disability. Now, many times I find that doctors' records suffer from a disease that I've just discovered, and I call it the document deficiency disease. Now, most disability carriers, as I said, are going to review your medical records because they have a fiduciary duty to investigate your claim. Now, while there's no contractual obligation for the insurance company to request the medical information on your behalf, it's generally your responsibility to provide them with the proof of your entitlement to benefits. Now, that doesn't mean they aren't going to get the records. In fact, most of the time they do get the records. But what happens that can be problematic is that your medical records, as I've said, don't support your disability claim. They don't have information regarding your symptoms and functionality, the diagnosis, the objective basis of the diagnosis, the objective basis of the restrictions and limitations. Now, the next problem is sort of a compounded problem, is that attending physician statement form, the APS form. And I think they also suffer from documentation deficiency disease. Properly completed APS forms are the key to getting your benefits. Now, I will also explain to you that many times the APS form doesn't ask the right questions on purpose because the carrier doesn't want to know your true restrictions and limitations. I, as a matter of course, will either amend or supplement that APS form with a Social Security Disability Residual Functional Capacity form. Well, what's that? We use them in a Social Security disability claim, and they've been developed by lawyers such as myself to really get at the meat of the diagnosis and, more importantly, the restrictions and limitations. And the APS form is really designed for the doctor to say that you can work in some capacity, preferably a sedentary capacity, while the residual functional capacity forms, on the other hand, are really designed to get at your true restrictions and limitations, and not pigeonhole you into a carrier-type analysis of your restrictions and limitations. Now, I have found that doctors don't always understand their role in documenting medical records or filling out attending physician statement forms. And so if you're having these problems, I think there are three suggestions that you should consider. First, you should have an open, off-the-record discussion with your doctor about the requirements that you have to meet for disability benefits. Once you explain what you have to prove in terms of the definition of the disability and your occupation, you want to make sure that the doctor understands that and also understands that the disability carrier is going to be asking to look at your records and to fill out forms. It's also appropriate, I think, number two, to ask your doctor to incorporate into your medical records any activity of daily living forms that you've completed, together with that interval history form I talked about, that symptoms and functionality sheet. And you want to also make sure that your doctor is documenting your treatment plan and what that treatment plan consists of, and the fact that you're getting regular and appropriate care. The carrier also has a tendency to deny claims on the basis that people aren't getting regular and appropriate care. So you want to make sure that in this open discussion with your doctor that they understand that you need to be seen on perhaps more regular intervals than normal, especially at the beginning of your claim, because the carrier is going to look at the frequency, duration, and nature of the care that you're getting. Now, the third thing that's important is in this open discussion that you learn whether or not the carrier can rely on, you understand if the physician does not support your claim or is not going to be cooperative. If the doctor says, I don't think you're disabled, or I'm not going to fill out the forms, then you're in trouble. I know that your doctor may be the best doctor to treat your condition, but if they don't support your claim, you don't have a claim. And if they're not going to treat you on a regular basis, you're not going to have a claim. So I want you to understand that medical care is appropriate and necessary, not only for your medical condition, but to address your true restrictions and limitations. You've got the burden of proof and not the doctor. Now, one of the other things I want to talk about quickly is that you may have a medical condition where there are no known tests or objective data, and your doctor has to make a clinical diagnosis based on your physical examination or your subjective complaints. This is common in cases like Lyme, fibromyalgia, chronic fatigue, RSD, depression, panic attacks, multiple sclerosis, vertigo. There's a lack of objective evidence generally to form a diagnosis. And the carrier is going to want to see how the diagnosis was arrived at and the objective basis ultimately for the restrictions and limitations. Remember, carriers are in the business of collecting premium, not paying benefits. And they're going to hire a staff attorney or a liar for hire peer review doctor whose sole job it is to review your claim and render an opinion that your doctor's diagnosis of your medical condition isn't based on objective medical evidence and that it's not supported by diagnostic studies, or that the restrictions and limitations are not supported. And you can see that having an experienced ERISA disability attorney to assist you in reviewing your records before you stop work or appeal a case is really crucial in getting the disability benefits you deserve. So let's take a break. I know I covered a lot of stuff, but this is important stuff that you need to understand before you stop work and apply for your disability insurance benefits or appeal a wrongful denial of your claim.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.